Hello, and welcome to my living room here in North London. My name is Christopher Desira. I'm a solicitor at a law firm called Seraphus. Seraphus is a law firm that's advising the EU delegation to the UK and the EU embassies on UK immigration law and the EU settlement scheme. Now, I'm going to get a few housekeeping notes out of the way, and then we'll get into the substance of this recording. First of all, I'm on my own here today. I'm trying to man the video and the questions and the answers. So apologies if the video is a bit rough and ready. Second of all, I'm going to use the term EU citizens a fair few times in this video. When I say EU citizens, I mean nationalities of the European Union, nationalities of the EEA states, and Swiss citizens. Third of all, I'm in my living room in North London because I'm recording this during the COVID-19 crisis. So I just want to wish everyone safe and well messages. I hope you're all okay during this period. And hopefully this video will ease some of the anxieties and questions that you have about the EU settlement scheme during this period. This video is going to cover two main segments. One of them, I'm going to summarise the EU settlement scheme so we know roughly what we're talking about. And second of all, I'm going to answer some questions that were sent in to me before I recorded this video. And hopefully by the end of this video, you'll have some more answers and some more assistance on what you need to do with the EU settlement scheme. First of all, about the EU settlement scheme. Now, the point of the EU settlement scheme is that when EU law ends, we need to swap our residence rights under EU law with residence rights under UK immigration law. And that's the point of the EU settlement scheme application process, is to apply to the UK Home Office for the equivalent UK resident status. The application process is built to meet some core requirements in order to be granted one of two statuses. You can only get one of these two statuses and are linked to the length of time you've been residing in the UK. The first one is settled status. Settled status is granted to anyone who's been resident in the UK for a minimum of 5 years. Settled status is a permanent status. It means you can live in the UK permanently, and it's very hard to lose your settled status, and it's fairly secure. The second status is pre-settled status. So pre-settled status is granted to anyone who has been residing in the UK for less than 5 years. The point of the pre-settled status grant is to allow you to live in the UK for up to 5 years, and then once you've lived in the UK for 5 years, you can then apply again, but this time for settled status. How you get either pre-settled status, settled status depends on you proving a number of factors. First of all is proving your identity and nationality, and also prove your family relationship if you're the non-EU family member of an EU citizen. Second of all, we need to prove the length of residence because that dictates what status you get. And then third of all, we need to undergo a criminality assessment because the Home Office may consider refusing applications only where serious criminality occurs. It's quite a high threshold, and serious offending means in most cases someone who's had a criminal sentence that requires imprisonment of 12 months or more. So that's not going to be relevant for a great number of people. So I just want to make sure that if you don't worry if you've got a speeding ticket or a parking fine, that's not going to prevent you from applying to the scheme or prevent you from getting a status under the scheme. If you do have an offence, it's important to disclose it. If you're not sure whether you disclose it, you need to disclose it or not. If you're not sure whether it's serious or not, don't pay a lawyer to ask these questions. Just give the Home Office every bit of information that you have, and they can make the assessment themselves. In most cases, it won't be important enough to affect your settled status or pre-settled status application. That's the real key here when making applications to the Home Office, is to make sure that you answer all of the questions, you answer all of the questions honestly, and you make sure that you provide all of the information you need. And if you're not sure whether to provide it or not, the best case is to provide it, because if you fail to provide something you should have done, the Home Office may well refuse the application for that reason alone. The settled status application can be made for a lot of people entirely digitally. And if you can do that, then you can do your application relatively quickly, and you'll probably get the status relatively quickly too. Now, to do that process entirely digitally requires a two-stage process. The first one is to prove your identity and nationality. You do that by downloading a mobile app onto most Android devices and Apple iPhone devices of iPhone 8 and above. If you can download the app from either the Google Play Store or the Apple App Store onto a compatible device, then you can scan your national ID card or your national passport using the mobile device, using the app. And then the app will transmit that data to the Home Office. Then you've confirmed your nationality and identity. Having done that step, you'll receive an email from the Home Office that will invite you to click the link to complete the rest of your application process using any web browser on any device. So the first step is downloading the app to confirm your nationality and identity, and then the second step is to use any web browser to complete the rest of the online application form. Now, if you don't have a biometric passport or a biometric national ID card, or are not compatible, then there may be a bit of obstacles during the COVID-19 period, and that's one of our questions, and I'll get onto that in a little bit. If you don't have a compatible device, then ask someone within your household if they've got a compatible device that you can borrow to use this app. The app doesn't retain data. The device you borrow won't retain any data, according to the Home Office, so you could borrow someone else's device within your household. It has to be, unfortunately, within your household during this period because of the social distancing rules that are in place. So if you can do the process entirely digitally, within a short period, the Home Office will email you back and say we've granted you either pre-settled or settled status, and it will the email will have a PDF document attached to it that will explain to you what that status means and how to access your status. Because if you're European, your status will be entirely digital. If you're non-European, then you may have a physical status if you don't already hold one. So that's roughly the EU settlement scheme as an overview. Now let's get to your questions, and we've got a few questions sent in to me for this video, and I'll try my best to get through all of them with the time that we have. So the first question is relevant for us right now, and that is, what impact will the coronavirus crisis have on the EU settlement scheme? Now, it's impacting the EU settlement scheme in a few ways, mainly because of the social distancing and isolation requirements that are in place to reduce the spread of the coronavirus. It means that the Home Office have significantly reduced their services, and in some cases have closed some of their services entirely. So I'll summarise how that affects you. Again, if you can make your application entirely digitally, then you can still do applications during this period. The problems arise where you can't do the process entirely digitally, or you are required to submit further evidence to the Home Office. So let's go through these one by one. The first impact the coronavirus is having is on the Settlement Resolution Centre. This is a call centre set up by the Home Office that can help people through the process. This call centre has closed for the foreseeable future. The second obstacle we have is if you need to post your passport or national ID card to the Home Office because you can't use the app and you can't borrow someone else's device within your household, then you won't be able to make an application during this period, because the Home Office are preventing applications using non-biometric ID, passports and national ID cards for the moment, until they're able to resume their normal staffing levels. Another impact is that because of social distancing, public centres where you can go and get your passport and national ID card scanned are closed. They're called document ID scanning locations, and there's a great number of them spread across the UK. All of these centres are closed, so you can't go out and scan your passport and national ID card. Another impact is that the Home Office are requesting people don't post documents to them during this period because of their staff reduction levels. Now, the last impact is that decision making during this period is going to be delayed because, again, the staffing impact that they have. Not everyone within the Home Office can work from home, and in some cases it's not safe for data security reasons to work from home. So decision making during this period may be reduced. That said, if you can apply it entirely digitally, you can still continue to do so. If you can apply entirely digitally, your processing times may not be significantly delayed, but there is an impact during this period. Now, the next question on the list is, would a Brexit extension mean an extension to the deadline to apply for settled status? Now, Brexit extension in this question, I imagine means an extension to the transition period. Now, there's a couple of things we need to discuss so we can have a full understanding of this question and answer. Currently, right now, we're in what's called a transition period. The UK has left the European Union, and the UK left at 11 p.m. on the 31st of January this year, 2020. The UK is no longer an EU member state, but we have a transition period until the end of 2020 because the UK is not ready to leave the legal framework of the EU and all of the other procedures and policies that are in place. So all of EU law and everything that the UK is a member of has been automatically extended until the end of 2020 to give the UK time to negotiate their way fully out of all of this and also to implement their own replacement systems, services and laws. Now, the transition period means that EU free movement law for the purposes of us residing and continuing to reside in the UK is also extended until the end of this year. So you should not feel any differences in the way you live your life in the UK, the way you travel in and out of the UK during the transition period. The deadline to the EU settlement scheme is locked into the transition period and the withdrawal agreement. The withdrawal agreement is the agreement the UK and the EU signed for the UK to leave the EU on the 31st of January. The withdrawal agreement talks about the EU settlement scheme deadline, and it says in the transition, it says in the withdrawal agreement that the deadline to the EU settlement scheme, if you want to have an EU settlement scheme, is that the deadline will be no earlier than the end of the transition period plus 6 months. This means that the UK and also any EU country, because every EU country also needs to figure out how to protect the resident status of British citizens abroad, has to build an application process. And if they build an application process, the deadline to the application process needs to be by the end of the transition period plus 6 months. So the current deadline to the EU settlement scheme meets that requirement in the withdrawal agreement because it ends on the 30th of June 2021. So that's the end of the transition period this year plus 6 months. Now, if the transition period is extended, that means the terms of the withdrawal agreement is extended, then it will also extend the deadline to the EU settlement scheme because the deadline is linked to the withdrawal agreement, which talks about the transition period. If the UK asks for an extension of the transition period, they have to ask for an extension by June, and that extension will be no less than a year. So which means if the UK asks for an extension of the transition period will be added an extra year, which will bring us to the end of 2021. And because the withdrawal agreement says the deadline for the EU settlement scheme needs to be the end of the transition period plus 6 months, that will extend the deadline to the 30th of June 2022. So if there's an extension to the transition period, there will be an extension to the settlement scheme, and the extension to the settlement scheme will be June 2022. Now, we don't know when that's going to happen, and we don't know if that's going to happen. So it's important to continue to assume the deadline's the 30th of June 2021 and continue to work towards that deadline. Don't assume it's going to be extended, because it may well not be, and then you may inadvertently miss the deadline. So until we know otherwise, the deadline remains the 30th of June 2021. Now, the next question I have is, how can I demonstrate that I have settled status if I have no physical proof? Now, it's quite difficult to prove if you have settled status if you have no physical proof. I don't know if the person who's asking that question is asking that they only got digital proof of residence, or they got no proof of residence at all. Now, how you prove your eligibility for settled status is by proving you've been in the UK for 5 years or more. Now, how that is done in the application process is in the two-stage process. First of all, there's an automated check. So when you fill in your online form, you're going to tell the Home Office, I've been in the UK, residing here for 5 years or more, and I'm going to put my national insurance number into the form, and then the national insurance number will trigger automatic checks with HMRC and DWP. Both those government departments will ping back to the Home Office whether they've got records for the 5-year period or not, or whether there's gaps in that period or not. Now, if the automated checks ping back to the Home Office and say, we've got these 5 years that you asked for, then you're not going to need to provide the Home Office any more information, because the Home Office will be confident that you've been residing here for 5 years, and that because you've been residing here for 5 years, you should be granted settled status. Now, the automated checks only check the most recent few years. So if you're relying on a 5-year period going back some time, the automated checks won't work. If you've got gaps in HMRC records because maybe you've been in and out of work, or you've got no records with the Department for Work and Pensions because you never received benefits, then there's going to be gaps in the automated checks, then it's not going to work for you either. So in either of those cases where you need to provide more evidence, that means you're going to need to prove your residence in the UK to the Home Office. If you need to prove your residence in the UK to the Home Office, you're going to need to do that by sending either digitally or by post proof of your residence in the UK. Now, what proof of residence will be acceptable by the Home Office? Well, that will be anything that has your name, dates and address on it. What the Home Office like to see is the kind of evidence which they can verify themselves or are fairly confident are genuine. So it's the usual stuff you might always be expected to provide in applications like this. These will be bank statements, pay slips, P60s, utility bills, council tax bills, mortgage agreements, tenancy agreements, and so on. The kind of stuff which they can verify quite easily. The stuff which they prefer not to see, but they can continue to use and will accept, is anything outside of that bracket. So that will be mobile phone bills, junk mail, there'll be membership letters, anything with your name, date and address on it, which will be harder for them to verify, but they will still continue to accept. There's a few rules about the residence evidence that you provide. First of all, it needs to be dated, and the date will only prove the period of residence that the document is dated within. So if it's a monthly bank statement, it will only confirm that month. If it's an annual bank statement, it might confirm the whole annual period. The paperwork also needs to demonstrate you are probably living in the UK. So if you provide an annual bank statement, the annual bank statement has to have continuous transactions in it. And those continuous transactions will prove to the Home Office that you live in and in the UK because you're spending money and you're receiving money in the UK. If you provide an annual bank statement with only one transaction in it through the whole 12-month period, the Home Office will ask you for more evidence because that one transaction doesn't necessarily mean you've been living in the UK for the whole year. The Home Office also prefer not to see evidence that they can't verify or they're not confident that they can verify it. That's things like photographs, letters from friends and family members, anything which is difficult for them to confirm and verify. That said, if that's all you have, then you provide what you have, and then the Home Office will always ask you for more evidence or more information if they need to. It's fairly easy to prove your residence in the UK in this manner. You don't need to provide evidence for every single month over the 5-year period. If you provide enough evidence for 6 months in every 12 months of the 5 years, then the Home Office will accept it. Again, provide what you have, and if the Home Office need more, they're obliged to ask you to provide more. They can't just reject it without asking you to supply more evidence. As I hinted early on in this video, the COVID-19 crisis is impacting this in a little bit, because if you can't send this information to the Home Office digitally, or you can't upload it to the online form digitally, and you are required to post things to the Home Office, then the Home Office are not accepting evidence by post during this period. So there will be a delay in your applications if you are required to send things to the Home Office because you're unable to. So just check the Home Office website for updates on when you can post things to them. If you've got no evidence of your residence in the UK, none at all, and you can't find anything, then the Home Office will, if they can't figure this out and help you prove it, then the Home Office will probably grant you pre-settled status. Pre-settled status will mean you'll get that 5-year residence permit. When you get that 5-year pre-settled status residence permit, it will give you the opportunity to make sure that you start saving evidence of your residence in the UK. So it'll be important if you are in a position where you've got no evidence at all that you've been in the UK for the 5 years, and you're never going to be able to prove it, you'll get pre-settled status. When you get pre-settled status, start setting up things in the UK that will give you that evidence later on in 5 years' time. So set up a bank account, use the bank account if you can, get a mobile phone bill sent to you, start thinking about the paperwork you can start saving. So in 5 years' time, when you're ready to apply for settled status, when you're ready to move from pre-settled to settled status, you'll have the evidence at that point. So the next question. Is, if you have been living in the UK for less than 5 years, is it better to apply for pre-settled status or wait until you are eligible for settled status? Now, this question really depends on whether you've got time to apply for pre-settled status and settled status, or whether you're running out of time and you need to protect yourself. So it may be better if I give you an illustration. So if someone's been here for 4 years, in a year's time they're going to be eligible for settled status. In a year's time will bring us to March 2021. March 2021 will be before the deadline. So because March 2021 is a few months before the deadline, that person has a choice, because they have time, to either apply for pre-settled status and then apply for settled status in March 2021, or wait until March 2021, forget the pre-settled status application and just apply for settled status directly without going through the pre-settled status route. So you have a choice whether to wait until you've got a 5-year period, then do your settled status application, or apply for pre-settled status now and then apply for settled status when you're ready. It just depends on when you are going to hit that 5-year residence period, and when you do, it's enough, you left yourself enough time before the deadline to do so. If your 5-year residence permit is going to end very close to the June 2021 deadline, I wouldn't recommend waiting until then, it's safer to get pre-settled status than apply for settled status, because my worry is you might miss the deadline because it will be so close to the deadline. So it's just about when you hit that 5-year residence period, and so long as you've got enough time to wait and apply for settled status before the deadline is met. The next question is, will I be able to vote in the UK once I have pre-settled or settled status? Now, voting in the UK is not linked to pre-settled or settled status. And there's a couple of main instances when you can vote. One of them is in local elections and one of them is in general elections. Now, local elections will be up to the UK to decide whether those who have pre-settled and settled status will be able to vote in local elections. The UK has said that it can continue to vote in local elections during this year, 2020, but of course those local elections are now postponed because of the COVID-19 crisis. And beyond the end of this year, the UK has not made a decision on whether voting will be allowed in local elections from 2021 onwards. General elections, it won't be enough to have settled status or pre-settled status. You'll need to have citizenship to do so. If that might be one reason why you might want to become British, if, for example, you want to participate in general elections. So voting is not linked to getting these statuses. They're still linked to domestic decisions about whether the UK government wants individuals with settled status to vote in particular elections. The next question is, can I retain settled status if I leave the country for 5 years? Now, those who have settled status can keep settled status so long as they are not absent from the UK for a continuous 5-year period. This means that if you get settled status, you will be able to leave the UK, you'll be able to live somewhere else, and you'll be able to study somewhere else for 2 years, for 3 years, and retain settled status. Now, if you know you're going to be outside of the UK for 5 years or more, it's important that you return back to the UK to break your absence. And you can do that by coming back for a short weekend or holiday. And then when you leave the UK again, you will be allowed to again be absent for up to 5 years to retain your settled status. So it's quite easy to retain settled status. And this is one of the main positives of having settled status. It allows you to be outside of the UK for up to 5 years and continue to retain it. And if you need to be outside for more than 5 years, you need to come back to the UK to break your absence and leave again, and then you can continue to retain it. I say this is one of the benefits of settled status because there is another status which is non-settled status called indefinite leave to remain, but non-settled status indefinite leave to remain. That means someone may already have a permanent status in the UK, but not through the settled status process. Now, if someone has indefinite leave to remain, but not granted through the settled status process, they can retain it, but only up to 2 years absence. So settled status gives you that additional 3 years, 5 years in total, to be absent from the UK and retain it. So it's quite good in that respect. Those who have pre-settled status have different requirements to meet. And it's much more important for people with pre-settled status to be careful with the number of days they're outside of the UK. If you've got pre-settled status, you can only be absent for up to 6 months in any 12-month period. And that's not a block of 6 months. That's all your absences during that 12-month period added together cannot be more than 6 months. If it's more than 6 months, you're entitled to one absence of up to 12 months. That's one in the 5-year period of up to 12 months for a very serious reason. Very serious reason are things like vocational study, sickness, pregnancy, working. So it's quite restrictive on your reasons for being outside for up to 12 months. Just being on holiday or just living somewhere else won't be enough. If you are from a country that requires you to comply with compulsory military service, then your absence is permitted for the whole duration of that compulsory military service. So it's really important if you're on pre-settled status to make sure you continually reside in the UK. So basically be in the UK for more than you're not. Because if you are outside for too long and you're not going to meet any of the exemptions, when you come to apply for settled status, your settled status application will be refused and you won't be able to get settled status. So if you have pre-settled status, be careful with your absences. Now, the next question is, will I have a right of appeal once I have settled status? Now, this question is confusing two things. You will have a right of appeal if you are refused settled status. You will have a right of appeal if you are refused pre-settled status. If you get settled status, then you've been granted settled status and you've been granted successfully. There is no reason for a right of appeal because you've got the status that you want. Okay. If you get pre-settled status, but you think you should have got settled status, then you can appeal that decision also. But if you get this pre-settled status or settled status, and that status is the right status based on the length of time you know you've been residing in the UK, then you will get a right of appeal, but there's no point using it because there's nothing you can appeal because you got the right decision. So I think that covers that question. Now, the last question in the list is, if possible, I would rather apply for citizenship. I understand that I can do so 1 year after obtaining settled status. Is this correct? What is your advice? Now, I need to break this question down a little bit so we understand what it means. Now, anyone can apply for citizenship so long as they meet the requirements for citizenship. One of the requirements for citizenship is that you are free from immigration control. Free from immigration control means you have indefinite leave to remain, or you have settled status from the EU settlement scheme, or also you have permanent residence by virtue of EU free movement law. Now, if you have any one of those statuses, then you can apply to become British if you have that status and you have had that status for at least 12 months. There is an exemption to this, is if you're married to a British citizen, you don't have to wait 12 months once getting that status. As soon as you get that status, then you can apply to become British. But it's only if you're married or in a civil partnership with someone who's British. So once you get settled status, you can apply to become British, but you will have to wait 12 months with settled status before you can apply to become British, unless you're married to someone who's British. So that's how it will work with citizenship applications. Now that's the last question that I have on the list that I can fit in with the time that we have. I hope all of this information has answered some of the questions that you have about the settled status process and how it all works. Again, the process is relatively simple. You need to prove your identity and nationality, and also prove your family relationship if you're the non-EU family member. You need to prove you've been residing in the UK for 5 years if you want to get settled status. If you've been living in the UK for less than 5 years, you will be granted pre-settled status. When you're granted pre-settled status, you must make another application later on to get settled status. Pre-settled status doesn't automatically convert to settled status. You must apply again. If you've got any very serious criminal offending, then it may have an effect on the outcome of the application, but the Home Office still needs to make a proportionate decision. If you've got any kind of offending, make sure you include it on the form so the Home Office are aware of it. It probably won't have an effect on the outcome unless it's very serious. Currently, during the COVID-19 crisis, you can continue to make applications, but those applications must be made entirely digitally. If you know that you need to post your ID document to the Home Office, or you know you will be required to post things to the Home Office, it will prevent you from making applications or continuing your currently existing application. The best thing to do to keep an eye on what's happening with the settlement scheme during the COVID-19 crisis is to check the .gov.uk website. I wouldn't normally look on the .gov.uk website directly. Use Google. You're not cheating in any way. All lawyers use Google because it's immensely difficult to find things navigating through the .gov.uk website because it's a huge website. So use Google, type in, for example, EU settlement scheme document ID scanning location, and then you'll find a link immediately, and then go into the page and it will have COVID-19 updates. If it says that these locations are still closed and you can't use them, if it says they're now open, then you will be able to. But this video has been made on the 29th of March. I suspect we're going to be facing the COVID-19 crisis for a few more weeks, so I wouldn't expect any changes immediately. So if you can apply entirely digitally, do so. If you can't, maybe it's best to wait to see when the services will be back up and running. Now, in the meantime, I just want to say thank you for watching. Thank you for joining me on this video. I hope it wasn't too dull. I hope it was fairly professional, and I'm glad you stuck through it to the end if you have. And if you have, I hope you stay safe and well, and I hope everyone around you, your friends and family, also stay safe and well, and hopefully we'll be able to speak in person one day as I'll come and visit locally and do one of these sessions face to face. In the meantime, take care. Thank you.